2092 and on HB 2117. So we'll take 2092 first. And staff, could you give us an overview?
Thank you, Mr. Chairman, members of the committee. This bill concerns professional employer organizations, or PEOs. There is a legal definition of those types of organizations. It's very legalistic, but generally speaking, a professional employer organization is a business that provides administrative services for small and medium-sized businesses. So they provide stuff like payroll, benefits, HR, tax administration, et cetera. Starting here in the first part of the bill, it concerns registrations. Current law provides that a PEO's registration with the Secretary of State expires 120 days after the end of the registrant's fiscal year. The PEO registrant is required to renew its registration within that 120-day period. The bill would change this to state that registrations expire on October 15th, following the issuance of the registration. However, registrations issued on or after January 1st, 2025 would expire on October 15, 2026. And I'll flag that. I'm not sure if that date's supposed to be October 15, 2025, but I'll let the conferees speak more on that. Next, current law provides that the PEO applicant for registration must submit the most recent financial statement audit for such PEO or the PEO's parent holding company at the time of initial registration. The PEO must then file succeeding audits annually thereafter within 120 days after the end of the PEO's or their parent holding company's fiscal year. So the audit submitted with the initial registration must not be older than 13 months. The bill would change the timing of the audit filing requirements to coincide with the annual filing of the registration renewal application. The bill would keep the 13-month recency requirement for the initial audit submitted, but succeeding audits filed with renewal registration applications could be no older than 12 months. Next, current law requires a PEO to maintain positive working capital as reflected in the audited financial statements submitted with the initial and each renewal application. If a PEO does not have sufficient positive working capital, the PEO must submit a bond, irrevocable letter of credit, or securities with the Secretary of State with a minimum market value equal to the amount necessary for the PEO to comply with the positive working capital requirement plus $100,000. The bill would keep this requirement, but would strike the reference to an irrevocable letter of credit or securities. It would also strike the word market. So if they don't have a positive working capital, they have to submit a bond with the Secretary of State with a minimum value equal to the required amount. With that, I'd be happy to take any preliminary questions.
Are there any preliminary questions? Seeing none, thank you very much. Our first proponent is Mr. Clay Barker, Deputy Secretary of State. Welcome again.
Thank you, Mr. Chair. Clay Barker, General Counsel for the Kansas Secretary of State. And we were a proponent. We brought the bill, HB 2092, which went through the House without opposition. Some quick background. In 2012, the legislature enacted the PEO Registration Act, which required professional employer organizations to file with the Commissioner of Insurance. And last year, the legislature, at the request of both the Secretary and the Commissioner, moved that filing requirement from the Insurance Commissioner to the Secretary of State. It's gone extremely well. We've worked with the representatives from the National Organization for PEOs. And now that we're in the business of working with them, we ask that what we believe are pretty small changes to the bill process be approved by the legislature. The first, and just again as background, there's only 248 PEOs in Kansas. It's a pretty small number of entities, and as described, they provide a service mainly to small companies that a company can focus on its core competency, but gets these, they're not quite temporary employees, but they're employees of the PEO that come to the company and might do their accounting, their benefits, those sort of side areas that need some specialization so the company can focus on its core business. But the PEOs are required to file an annual report every year. Currently, it's tied to their fiscal year, and we want to change that so they all file at the same time, which is October 15. And the majority of PEOs file through national organizations that do their filing for them in all states they operate in. So that's not a big problem for them. And that annual report has not only a form with some basic information, but it has their basic financial documents in it also that we look over. We don't actually audit the documents, we just review them. The second change is that if a PEO has negative working capital, and that's defined as current assets minus current liabilities, and as far as we know, no PEO has ever had negative working capital in Kansas. They're supposed to file right now with the law a bond, an irrevocable letter of credit, or securities in a certain amount that's defined in statutes, the shortage plus $100,000. We want to limit that just to bonds because we're much more used to working with bonds, and the PEOs have no objection to that, removing letters of credit and securities as a way of making up the shortfall. And then as a last point, now this is not in the bill because we don't need legislation for this, but we're waiting for a few other bills to see if they're going to come through for us. And as soon as the legislative session is over, we're going to be introducing a pretty broad reduction and elimination of fees in our office. And that's going to include, whether this bill passes or not, but a reduction in the fees for PEOs from either $1,000 or $500, depending on what they're filing, to $250. So they'll be seeing some savings. Now, that doesn't have to do with this bill, but it's part of a three-point program we have for PEOs. And with that, Mr. Chair, I'll stand for questions at the appropriate time.
Thank you. We'll take questions. Do we have any questions? Seeing none, thank you very much. We appreciate that. Our second proponent is Erica Brun, CEO of Level 1 PEO. Welcome to the committee.
Thank you, Mr. Chairman and members of the committee. Thank you for the opportunity to testify today. My name is Erica Brun, and I am the CEO of Level 1 PEO, headquartered in Overland Park, Kansas. I also serve as the Leadership Council Chair for the Heartlands region for the National Association of Professional Employer Organizations, or NAPIO. NAPIO is the national trade association that represents the professional employer organization, or PEO, industry. By way of background, PEOs provide human resource services to small and mid-sized businesses, paying wages and taxes under the PEO's EIN, offering workers' compensation and risk management services, and providing compliance assistance with employment-related rules and regulations. PEOs have been operating in Kansas for decades. The bill before you today updates the Kansas PEO Act to reflect a set renewal date of October 15th for PEO licensing renewals and removes the irrevocable letter of credit or securities requirements for a PEO. NAPIO has worked closely with the Secretary of State's office on these proposed changes to the Kansas PEO Act, and we appreciate the Secretary of State's thoughtful consideration and collaboration with our industry on how their office can improve the registration and renewal process for PEOs. Thank you again, Mr. Chairman and members of the committee, for allowing me to testify today in support of House Bill 2092. Happy to answer any questions.
Stand for questions. Do we have any questions? Seeing none? Thank you very much for coming today. We appreciate that. Are there any opposition? Any neutral testimony? Seeing none, we'll close the hearing on House Bill 2092 and move on to House Bill 2117 and first staff overview.
Thank you, Mr. Chairman, members of the committee. House Bill 2117, as introduced, would make various amendments to Chapter 17, which covers corporations, and Chapter 56, which covers partnerships. The bill would modify certain business filing and fee requirements for business trusts, foreign corporations, and limited partnerships. It would authorize professional corporations or limited liability companies formed or organized to render a professional service to participate in transactions under the Business Entity Transaction Act. And then lastly, would remove a current open records exemption for certain information provided by registered agents. So I'm just going to quickly try and go down the line. I put together a comparison chart in my brief that marks out the specific differences. I didn't really notice like a specific underlying theme in all of the changes. They seem to be general updates. So first, Section 1 is Chapter 17, Article 20, which concerns trust companies and business trusts. A business trust can surrender its authority under current law by filing a certified copy of a resolution declaring withdrawal intent with the Secretary of State, 2, paying a $20 withdrawal fee upon filing a resolution, and 3, filing all required business entity reports and paying associated fees. The bill would replace the resolution filing requirement with a requirement to file a certificate of dissolution or withdrawal executed by an authorized person with the Secretary of State. It would also replace the current $20 fee with the fee that's required for dissolution documents under KSA 177506. And that statute says that the fee cannot exceed $150, but is set in regulations at $20. So for the moment, at least, it's the same amount. Next, Section 2 goes to Article 17 concerning foreign corporations. Under current law, foreign corporations operating in Kansas that merge with another foreign corporation or that amend their articles of incorporation must file a certificate attesting to the merger or the amendment. The bill would replace the requirement for filing a certificate with the requirement to file a form prescribed by the Secretary of State. Then Section 3, moving on to Article 78, which is the Business Entity Transaction Act. Under current law, certain entities are not allowed to participate in a transaction under the Business Entity Transactions Act. Such entities include professional corporations or LLCs formed to render professional services. That act, just a quick background, it allows for cross-entity transactions to take place with appropriate approvals and without having to dissolve an entity and without extinguishing any obligations owned by preceding entities in the process. And I guess that act was something that went into effect in 2009. So relatively new, and that's when those prohibited entities were included. So this bill would remove professional corporations and LLCs that perform professional services from that list of entities that aren't allowed to participate under the act. Next, moving to Section 4, it makes an amendment in Article 79, which is the Business Entity Standard Treatment Act. So under current law, a resident agent can resign without a successor by paying a fee and filing a certificate of resignation with the Secretary of State. The resignation is effective 30 days after filing. And then 2023's Senate Bill 244 added a requirement for the certificate to include contact information for an authorized individual to receive future communications from the resident agent. That Senate Bill 244 also exempted such contact information from the definition of public record under KORA. So this bill would remove that express exemption of the contact information from the definition of public record. Next, for sections 5 and 6, we're moving away from chapter 17 and going into chapter 56, dealing with partnerships. Section 5, under current law, the certificate of a limited partnership must include the name, registered office address, and resident agent information, each general partner's name and address, the dissolution date, and any other matters determined by general partners. The bill would simply remove the requirement of adding the dissolution date information to the certificate. And then in the final section, it concerns limited partnership fees. Under current law, specific fees are outlined for various filings, including amendments, certificates of cancellation, and certified copies. The application and recording fee for new limited partnerships is $150, both domestic and foreign. The bill would specify that the fees not to exceed $150 shall be established by rules and regulations of the Secretary of State. The bill will become effective upon publication in the statute book. I'd be happy to take any preliminary questions.
Questions? Seeing none, thank you very much. With that, our first proponent is, again, Clay Barker, Deputy Secretary of State. Clay, welcome again.
Thank you, Mr. Chair, and we appreciate you doing both of these bills. I realize you're not as big as some of the other issues in front of you. The revisor did a great job of explaining technically what these do. I thought I'd just sort of illustrate to you so you can visualize why this bill was brought. Every August and September, I sit down with our business services people, and we go over the top reasons why filings were rejected by our office, and then some other provisions that maybe the office thinks are inefficient or unnecessary. We look to see, is it on our end that we're not communicating with our customers well? If we think it's in the statute, we look to see if we think the statute could be changed. I talked to the Kansas Bar Association, corporate lawyers, the bankers, to see if they want particular provisions in there. And if no one objects, I bring it to the legislature. And we started out with about 20 ideas, and we whittled it down to these 6. And again, I won't go through the technical details, but so in the first section, which is business trusts, the oldest form of organization, right now it requires, if they're going to stop doing business in Kansas, they file a corporate resolution, which can be 50, 60 pages long. And then I, as the lawyer, have to take the thing, pull out a highlighter, and look through it for 4 or 5 specific pieces of information. And if it's there, we're good. And if not, we send it back. This would just replace that resolution with a simple 1-page document. Just tell us these 5 things, and you're good to end doing business. The second section is about foreign to foreign entity mergers. And in business language, foreign means non-Kansas as opposed to non-American. So Missouri, Afghanistan, it's all the same to us. But foreign mergers, right now the law requires they file certificates from their home state, and every state's different. So again, I may get 4 or 5 certificates trying to establish a few facts. All we want is a simple 1-page, just tell us what we need to know to satisfy the statute, and your merger's recorded. And this is just for public information. The third provision has to do with these professional organizations. Right now, and this is a real-world example, if a professional LLC, let's say a law firm, wanted to transfer or change its corporate or its structure from LLC to corporation, it has to go from professional LLC to regular LLC. That's one set of filings. Lawyers get paid. Then change itself into a corporation, and then change itself into a professional corporation. That's 3 steps, and we don't know why. Some of the lawyers that actually looked at this bill, one of them called me up 2 weeks ago and said, is that change still in the works? Because I've got a Missouri law firm that wants to change to Kansas and change its structure, and it would be a lot simpler if this was passed. And I said, I think it's going to go through. I hope it does. This would simply allow a professional LLC to change directly to a professional corporation in 1 step instead of having to do 3 steps. The fourth change had to do with the registered agents. If a registered agent resigns, again, they have to provide our office with information on a contact at the company. And that's not personal information. It's just Jane or Jim Jones is the president, and here's the corporate address. This is who you contact. We don't know why that was exempted from CORA, and what it causes us to do is to have to override our system and redact that from the form. And we get about 600 of those a year, so that just will save us a lot of time. The fifth provision, unlimited partnerships. The old way of doing business entities, corporations or whatever, you had to have a specific date when the entity would end, and usually it was 99 years and they would have to renew. Those were all eliminated, so entities can be perpetual if they want to. For some reason, the limited partnership statute still requires a fixed end date, and people file frequently and they just put perpetual, and we have to send it back saying, you got to give us a date, and they'll say why, and say it's in the law. We just want to take that out. Every other type of entity, LLC, LLP, corporation, trust, they can be perpetual if they choose to. And the last provision isn't so much a saving time and efficiency. It's a fee statute, like I mentioned with the PEOs, is we're looking to lower fees. Right now, the legislature has set the formation filing fee for a limited partnership at a straight $150. We'd like permission to lower it from $150 by regulation. So $150 is still the ceiling. For instance, with corporations, the statute sets the ceiling at 150, but allows us to set a lower amount, and we've set it at 75. Now, just so you know, that the money from those fees goes to SGF. It does not go to the Secretary of State's coffers, but there's not many LPs file in Kansas every year. It's about 150, And even if we were to eliminate the fee, it would only be $22,000. But we wanted permission to lower it so we can make all formation filing fees roughly equal regardless of the type of entity. And Mr. Chair, I'll stand for questions, and I hope that wasn't too boring in the detail, but this would help our office be just more efficient in just how we provide services to our customers.
Are there any questions? Yes, Senator Clement.
Thank you, Mr. Chair. So, Section 3, you were talking about just hypothetical, say there's a law firm that's set up as a certain type of an entity at another state, and to migrate them over efficiently to ensure they can run their operations efficiently here. This would help with that?
Yes, Senator. So that would actually be two different transactions. It's called a domestication, is which state is your home state, and then changing your structure from a professional, say LLC to LP, or professional LLC to corporation. This is where that would help. That'd make it one step instead of three.
From the example you used from a law firm, wouldn't they already be a professional on the other, in the state that they're in? Am I missing something in that?
Correct. They'd be, say, for instance, as an example, a professional corporation in Missouri, and let's say they want to be a professional limited partnership in Kansas. They would only need two transactions, change state and then change corporate form. Right now with the law, they'd have to do three separate changes to change form.
Let me add on to that if that's all right. So if I have a law firm in another state and they have satellite locations throughout the United States, are they able to today bring that under a single corporation in the state of Kansas?
They could if they wanted, and we never give advice on what form they should take, only help them get the form they ask for.
It would be doable.
I believe so, yes. And
Okay.
also with these professional entities, like medical, architecture, anything that requires professional licensing, the licensing board also has to approve if they're moving into Kansas.
Yeah, thank you, sir. Thank you, Mr. Chair.
Any other questions? Thank you, Clay. We appreciate you being here today.
Thank you, Mr. Chair. I appreciate the committee's time.
With that, we will close the hearing on HB 2117. Our plan here would be probably to work those tomorrow. And then the other thing we were going to do, we've been told that this session is getting closer to the end. So we're going to have a planning meeting right after this and determine which bills that we're going to bring it up and when. So we'll put a schedule together and have that done. So if there's anything else before the committee today? Not yet. If there's anything else before the committee today, we are adjourned. Thank you very much.
Ronnie's ready to go.